sir.
Good morning. Roger Schindler, Simon Schindler and Sandberg on behalf of the appellant. The issue in dispute.
Is Mr. Simon going to be here tomorrow? Because we had Mr. Sandberg yesterday, so I just want to see if we're going to have the whole show with us this week.
I didn't address that. That's Tobias Simon.
Okay, well then I guess.
Yeah. I had the privilege of working with Mr. Simon for many years. Here's where we are, and I would ask 2 minutes to reserve.
Okay.
Miami Real Estate is at all relevant times is a licensed broker. The defendants, the two corporate defendants, at no time were a Florida real estate broker. Beini, the individual defendant, is a sales agent effective March 2013 through January 2015. Throughout that entire proceeding, of that time period, she is a sales agent for Miami Real Estate, who is the broker seeking the commission, and was unsuccessful in the final judgment.
So we're quite familiar with the facts and the procedural history of the case. So let me ask you this. Given that our standard of review is competent substantial evidence, and that the trial court had a full trial and made findings of fact, even if the facts as you present them might have been compelling, how can we reverse the trial court's findings if there is competent substantial evidence to support those findings?
I anticipated that question.
As I knew you would.
In this particular case, I might be able to adopt the findings of fact of my opponent. They are well drafted and are right on point as to the factual issues. Therefore, if there are undisputed issues of fact, this court has de novo authority to decide whether the facts were properly applied, the law was properly applied to the facts. It is undisputed that the facts in this case support and give jurisdiction to this court and the authority to overrule and reverse the final judgment entered by the trial court, because the findings of fact are undisputed. If they were disputed, then you have a more difficult burden in determining whether or not the facts support the final judgment. Here, the fact I could use the facts supported and argued by my opponent.
So now you're going to tell us about the erroneous conclusions of law.
Yes, sir.
All right. Go ahead.
What's unique about this case, and 1 month ago, on May 2nd, this court addressed in Mass Capital versus Whitehall a very similar case. And in that case, a procuring cause was found for the broker and sustained by this court. What we've asked the trial court to do, and unfortunately we were unsuccessful, is to find that the conduct and the activities and the facts that commenced November 2013 through not less than August 2015 were a continuing conduct where the broker and its sales representative were completely and totally involved in the initiation, negotiations, and consummation of a multi-million-dollar 17-unit condominium purchase of units on right off Biscayne Boulevard by related group through its developer. Now, what happened here very quickly is that in November 2013, a businessman originally from China comes to Florida, contacts Beini, who is a sales agent who speaks fluent Mandarin, and the gentleman from New York, we call him Dr. Lee, does not speak English but speaks Mandarin. They meet for dinner, and the next day they travel to the office of the broker, owned by David Landau, who is the licensed real estate broker, and they get on their horse and off they go looking at properties in South Florida. What do they look at? They primarily look at the property being developed by related group through its developer, various development arms, and they looked at these 17 units which had not come out of the ground yet.
Okay, but I'm looking at the facts the trial judge found that you basically agreed to. paragraph 29, no evidence was presented that CCCC came to see One Paradiso because of Shu. Accordingly, even if Shu had informed plaintiff about CCC's interest in One Paradiso, no competent evidence was presented that CCC would have opted to work with plaintiff instead of Dr. Lee and Really Inc., with whom they had an established relationship.
There are 4 critical events that occurred, and I will address the court's observation.
Maybe I interrupted you, but I mean,
No.
doesn't that,
Here-
that's the fact, that's
CCCC.
the evidence, doesn't that?
No, CCC is a Chinese organization, very big organization, that came through Dr. Lee, who in the testimony and in the documents represents himself to be the partner. Dr. Lee testified on page 680 of the transcript that he is a partner with CCCC. Very significant issue. So, November, Dr. Lee is introduced to Beini Zhu and David Landau, and they go and they look at properties, and he ironically buys 2 units from the same developer in the latter part of 2013. What's the next critical event? And by the way, so that we all understand, the criteria for determining procuring cause are the initial putting together of the buyer and seller, which was recognized in the Mass case, and a legion of other cases going back 50 years. Respectfully, David Landau and his sales agent, and he had 5 or 6 Mandarin-speaking sales ladies, including Beini Zhu, a very competent sales lady, and they all went off looking at the properties, and she did communications for Dr. Lee. Dr. Lee was a partner. He's introduced to the project by David Landau, the broker, the appellant herein, buys 2 units. The next thing that happens, and this is completely absent from the brief of my opponent, in the second major event that occurs is that everybody goes to China. There is a May 2014 event in China promoting South Florida real estate. Who's at that meeting? Dr. Lee, the partner of the ultimate buyer, CCC, who incidentally, through Beini Zhu, negotiated at the demand of the developer to buy these 17 units in 17 separate LLCs.
The answer brief addressed it. In fact, they talked about it on page 5 of their answer brief. They talked about going to China for a promotional event, right?
Now, who's at that meeting? Dr. Lee, David Landau, Beini Zhu, and representatives of another organization, ISG.
Landau is your client.
Yes. David Landau is the owner and broker.
Gotcha.
And
I
under,
just wanted to make sure I was tying in your client.
and under the penumbra of Florida law, Beini Zhu or any licensed real estate agent can only work under a broker, one broker.
According to the answer brief, at that trial, the evidence was that no one from your client's company introduced themselves to CCCC. Is there evidence in the record to support that?
Dr. Lee is the partner. When Dr. Lee came in November, he's the one that brought CCC and ultimately the 16 LLCs that bought the units. CCC comes to New York, meets with their partner, Dr. Lee. They all come to Florida and they get together. But before that happens, there's a critical event that occurs. David Landau, the broker, takes Dr. Lee to meet a gentleman named Carlos Rosso, who is the second in command and related under Jorge Perez, and they meet for the entire afternoon, and Carlos Rosso, who is in charge of development of condominiums for the developer, explained the entire project that is ultimately in dispute here today. He shows them the plans and specifications. He introduces Dr. Lee to the project. Dr. Lee gets very excited about the project, and ultimately they then meet subsequently. So there are 4 critical events. The initial introduction where Dr. Lee buys 2 units, and he's identified through Dr. Beini Zhu and David Landau, the broker, that they are the sales agents representing this project and promoting it. Then there's the meeting in Beijing where the deal is promoted. Most importantly, and I think the critical issue is, the defendants, through their representatives and the partner, Dr. Lee, meet with the seller. And they all talk about this project. Then on July 12th, Dr. Lee returns with Beini Zhu and again meets with Carmen Casadilla, the sales agent for Fortune Realty, who is the in-house broker.
Is it legally significant that the trial judge found that Shu never told anyone that she was a real estate agent?
That's not the correct findings of fact. It's without dispute that Beini Zhu, the evening that they met, and then the next day they go meet with the broker and go look at the properties, Beini Zhu identified herself as a sales agent for the appellant.
I'm looking at the findings of fact 28.
What paragraph?
CCC, paragraph 28.
Most respectfully, without going through the record, it is without dispute. And by the way, to support that finding of fact
Well,
is...
here's part of it. CCC did not know Shu was a real estate agent, and did not authorize her to represent them in the one, how do you say Paraiso?
Paraiso.
I have to...
Okay, Paraiso.
There's two responses. As to the latter of those two issues, it is not necessarily on Florida law for the buyer to know who the broker is. But they did know because their partner, Dr. Lee, ran this whole proceeding starting in November when he bought 2 units, invited CCC to come to Florida. They all meet on July 12th, the representatives, with the seller, with Beini Zhu. What they did is they excluded Mr. Landau and his company.
So I don't mean to interrupt you, but you introduced your argument by saying that you could adopt the findings of fact by the court and even the statement of facts in the answer brief because this is a de novo review and an issue of law. But I've not yet heard you make a legal argument to this court. You spent the last 10 minutes telling us the facts.
I would adopt a very similar, the summary of the facts, not the conclusions by the court.
So
Now, as to the law, the criteria is very simple. For procurement,
Hold up, Mr. Shin. You need to wrap up in the next 2 minutes. Okay. Okay.
the criteria is introduction, the marriage is made on November by Dr. Lee and the appellant and his sales agent. And what's interesting about this case, which is unique to all these other type of cases, there's no hiatus. This is not a case where you have a broker, the broker proposes a deal, it doesn't go forward, and there's a hiatus of 6 months or a year, something happens and a new broker comes along and makes a deal, and the original broker finds out about it. This is a continuing negotiations from November 2000.
But I think how the trial judge was looking at was Shu, the sales agent of your client, wasn't functioning as a sales agent when she was escorting the Chinese buyers around. That she was just a translator, go-to person, driver.
It's a very creative argument, I would mention to the court. But if you look at Florida Statute 47501, it expressly identifies the definition of a sales agent. And it says, among other things, person is a broker who participates in procuring sellers, purchasers, lessors, or lessees who directly assists. And Beini Zhu, quote, assists. Beini Zhu told everybody she is a translator, she's driving the buyers around, and she assists in everything. What did she do? I'll just give 2 facts.
The statute's talking about assisting in the transaction.
She did. There's over 40 emails, which I refer the court to, where she did everything. She found the CPA, a man named Andy Chow, who spoke Mandarin, and she's the one that negotiated how they would structure the 17-unit purchase. She went to the title agent and asked, she said, I've got a client who's going to buy. I have a client. And the emails are replete with her reference that the client is Beini Zhu's, of course, through her broker. So the fact that she was also the translator begs the question. I would suggest that in South Florida, not less than 50% of the real estate transactions concerning offshore buyers are in a language other than English.
So a facilitating translator can be a procuring cause?
A translator, if that's all she did, then she'd just be a translator. But she wasn't. There are at least 40 emails showing that she did everything. She negotiated the deal, she promoted the deal, and she excluded David Landau. By the way, in that year, 2014, she made over $80,000 working for Mr. Landau's company. And this is the only transaction that she secretly did not disclose to Mr. Landau. And the Florida law says, if you made the introduction and you continued the negotiations absent any exclusion, and in this particular case, you have a unique situation because Beini Zhu, at all relevant times, is an agent for the broker. So the fact that she was acting as a translator, no problem. Did an excellent job.
We'll leave you 2 minutes for rebuttal.
I would only, if I may say one more.
Very briefly, please.
Very briefly. If you look at the Tassi case, which is Tassi versus Hall, it gives this court criteria. Florida Statute 475 is designed to protect Florida citizens. Very important. And it goes back many years. And it says that a foreign broker cannot be entitled to a commission for which they never sought. There is no relief claimed by any of the defendants for a commission. Beini Zhu at the last minute says yes, but I don't really need it. I don't really want it. So there's no relief sought by the defendants for any brokerage commission.
Did you argue Tassi or cite to it in either your initial brief or your reply?
The appellant, the appellee did,
Okay.
which was the reversal of a summary judgment, and it was never addressed on the merits. But the case is applied by the appellant because it defines exactly what the responsibility of a broker, and in order for a foreign broker, concluding, in order for, it's very important.
What
In order
page
for
of their
foreign
answer?
broker-
Sorry, what page of their answer brief? Because I can't find it.
But I'll get it on rebuttal, I'll have to look it up.
Very good.
But regardless of what, it's the only case that they cite was a reversal of a summary judgment. More important is, they describe in Tassi, the first district, that the purpose of the Florida Statute 475 is to protect Florida residents from miscreant and unscrupulous foreign brokers from another state. In order for a foreign broker to recover a commission in Florida, they have to have a cooperating broker. There is no cooperating broker. The only broker in this case was David Landau's company and the seller's broker, in-house broker. Thank you.
Thank you. I'll hear from the appellee.
Good morning, may it please the court. John Carlos Weisel on behalf of the athletes. Your Honors, even though the argument was posed as a legal argument, all we've heard were facts. And if we adopt the facts that are stated in the answer brief or the final judgment, the conclusion is clear. The court had ample competent potential evidence to support every finding. I do want to correct a couple of things that were said in the argument of my friend. He referred to Mr. Lee as CCC's partner. That comes from a page in transcript 640, and I want to read it to you because it provides context. He was not the partner in this transaction of the company, the buyer. Question says, where did you live in China? Answer, Beijing. Question, did you establish business connections when you were living in China? Answer, yes. So in either research, real estate, investment, those aspects. Question, did you testify that Hydroplan and Chairman Yu were friends of yours? These are individuals that represent CCCC. The answer is yes, they are my partners. So it was in the context of friendship in China that Mr. Lee was testifying that he had done business deals with them in China. That's the context for saying that they were partners. They were not partners in this deal. The testimony is very clear. The representatives from CCCC came from New York. Mr. Lee introduced them to the U.S. market. He sold them on the idea of investing in the U.S. market. He had to take them out to lunch, entertain them, and eventually it got around through research of his partner, Mr. Zhu, that there were projects in Miami that they were interested in. And so they decided, based on the trust relationship that they had with Mr. Lee, to come to Miami. And they actually came together. They flew down together for the purposes of Mr. Lee showing them around the city and showing them the projects. The only reason this case really is here is because on the visit to Juan Paraiso, before the visit to Juan Paraiso that same day, Mr. Lee injured his toe. And so he had to go to the hospital and couldn't accompany these individuals to the meeting with Ms. Casadella. the seller's representative.
But Landau introduced Lee to the project.
Well, no. Let me start there. When Mr. Lee first came to Florida, he came to Florida because there was a boat show, and he was recommended to come to Miami. And he didn't speak much English, so he found an interpreter, and that was Ms. Shu. So as he hired Ms. Shu to be the interpreter and show him around the city, Ms. Shu told him that she was a real estate agent and he should be looking into investing in Miami. This is November of 2013. So the next day, Mr. Lee meets with Mr. Landau, and they start a relationship whereby they want to investigate or research if they could work together as broker. And so they actually start doing that. And the first purchase was a result of that cooperation agreement. There was a cooperation agreement they entered into immediately. Like most broker-to-broker relationships, there's a broker-to-broker agreement. And pursuant to that agreement, each obtained a commission from that first sale. And that was a sale to Dr. Lee's wife. That's on project one bay. And months later, in April or May of 2014, the new project starts. That's the One Paraiso project. And so when that starts, well, there's everyone is trying to bring investors in independently. In fact, in June, when the cooperation agreement was terminated by Mr. Landau, he testified that each were trying to bring investors in, and pursuant to his testimony, Mr. Landau didn't have to provide Dr. Lee with any of the commissions that resulted from his own efforts, and likewise, Dr. Lee didn't have to bring every client to Mr. Landau. In fact, when all this broke down and the properties were sold in One Paraiso, when Mr. Landau found out, what he did is he went to the seller and requested a referral fee. He didn't say that commission belongs to me because she was working for me. In fact, he requested it as a special accommodation, a referral fee.
A discretionary.
Discretionary, which he claimed was done in other deals, even though it hadn't been done. But yes, it was an accommodation, not entitlement to a referral fee. And that was what transpired at trial. That was a testimony at trial. And after a full-blown trial, the trial court made very detailed findings of fact. And if we go by those findings of fact, the conclusion is clear.
So even if we find it somewhat difficult to swallow, that Ms. Zhu was hired solely as a driver, a translator, a concierge, scheduler, the trial court made that determination, and there is competent substantial evidence to support that determination, even if we, on a cold record, might not agree with that assessment, right?
Precisely. Judge, her testimony and based on the credibility of witnesses, made his own assessment.
What about the emails mentioned by your opposing counsel, where Shu said to the title company, "I have a client"?
Well, Ms. Shu testified about that extensively at trial. And at every instance, whenever an email was brought up to her, her response was the same. This is what Dr. Lee asked me to say. And of course, she would say it sometimes in her own words, much as the same way that I would tell my assistant, "Hey, talk to opposing counsel, get an extension for this brief." And
But in other words, she's calling a title company that's starting to look. That's not just getting reservations for lunch and stuff.
no, well, she was assisting Dr. Lee in many aspects, including taking them to restaurants and
Yeah, but I mean, this is
entertainment.
starting to focus pretty hardcore on purchasing real estate.
Yes, but
I mean, it looks like it's sales agent activities.
no. Well, the real distinction between a sales agent and someone who's an assistant is, I think, is borne out by the statute. 475 01 in the definitions. It says a broker, and this is a sales agent, means a person who for another and for compensation or valuable consideration directly or indirectly paid or promised, expressly or implied, appraises, auctions, sells, exchanges, buys, rents, or offers, attempts or agrees to appraise, auction, or negotiate the sale or exchange or purchase or rental of a business, enterprise, or business opportunities. Behind the definition of a broker is this idea that this person is going to get a commission from the work that she's doing. And in this case, she never claimed a commission. She never even tried to get a commission. In fact, that commission would have been 10 times more than her yearly salary, and she never even tried to claim a commission in this case because she always understood that she was never acting on behalf of CCCC. In fact, CCCC never knew that she was a real estate agent, and CCCC is the buyer here. Dr. Lee was not the purchaser. He was hiring her for purposes of entertaining his clients, and that was a relationship that was established at trial. And those were the findings of fact that were issued by the trial.
So you can summarize for us?
And so, in summary, the court had ample, competent, substantial evidence that was presented at trial. And based on that evidence, the court made detailed findings of fact that support the judgment of the law, and I would ask the court to affirm. Thank you very much.
Thank you. 2 minutes for your help. Starting with Cassidy
In
Hall.
response to the court's question to my colleague, Dr. Lee.
No, starting with Cassidy Hall. Where
Oh,
was it cited?
Tassifa Hall is cited in their motion to strike, which is
Motion
found.
to strike.
Tassifa Hall, I'm referring to that case to define for this court the purpose of 475, which is to protect Florida citizens. And what it says is that a foreign broker,
Motion to strike what?
Motion to strike in this court or in the
in
record?
the trial court,
In the trial court, and it's
Yes.
in the record?
yes,
All right.
yes. And the purpose of,
Was anyone paid a commission in this
my
transaction?
client came to me shortly before the first part of the commission was to be paid. We contacted the seller, and it was agreed by all parties that the
Record
funds
evidence.
be escrowed.
Record evidence?
Oh, yes, there's a stipulation adopted by the court. The stipulation adopted by the trial court says the money will remain in escrow with the seller until this matter is resolved.
Right.
So fortunately, we don't have to chase anybody.
This is not a situation where Lee got the commission or Shu got the commission.
They're claiming the commission, notwithstanding that they never brought any affirmative relief in the underlying case for a commission. And they can't because they're not a Florida broker. And to seek a commission in Florida, they would be violating both criminally and civilly Florida law because they need a local cooperating broker. There is no cooperating broker because the only other broker is my client who represents the buyers. And in response to the court's question to my colleague, Dr. Lee was introduced to this project repeatedly, 4 separate times by David Lee.
But your client broke with Lee,
No,
right? I mean,
There was a
you guys had a
cooperating-
deal that they would work together to do
for referrals.
sales.
For referrals, not on this transaction. And what happened was, because of the conduct of Dr. Lee, my client wrote and said, we can do separate deals in the future, but we should not be referring to each other, foreign business, Florida buyers going to New York buyers coming to Florida. That's all that happened. But notwithstanding that, even if there was an enforceable contract, we introduced this project to Dr. Lee, who is the partner, without dispute, by his own testimony in trial, of the buyers. Now, Florida law says, and it's very important, they went to see the developer. Dr. Lee went and met with the developer and said, tell me all about the project. The developer pulled out all the plans and specifications, and that project is now beginning to close as we speak. Now, respectfully, if Dr. Lee knew about it, he brought the people from China down here, his partners. They were introduced to the project. They showed the project on July 12th. But before that, Dr. Lee met with the sellers with David Landau. And Beini Zhu met with them in China. They all went to China to promote this project. So what's the issue here? You have a continuing negotiations by the sales agent, excluded the broker. And Beini Zhu says, I'm just a translator. Well, respectfully to this view, if all you have to do is translate for a buyer, then it would turn the whole real estate market on its head, especially in South Florida, because I would predict that half of the negotiations are done in Spanish or in another language. She brought David Landau the next day. They all went and met with the project. They bought 2 units. Dr. Lee bought 2 units. Continue.
In conclusion.
And in conclusion, we would ask 2 things. One, that the final judgment be reversed and remanded for judgment in favor of the broker. And number 2, as to Beini Zhu, who brought an action for breach of we brought an action for breach of contract, we would therefore prevail. That was not ruled on by the trial court because it wasn't necessary, because they found against my client that there's a prevailing party clause in the independent agreement between Beini Zhu and her broker. We would be awarded attorney's fees. Thank you.
All right, thank you all.